Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Imagine you're a defense attorney in a high-profile case. You have a client who is charged with murder, and the state has video evidence. They have forensic evidence from firearms. They have all kinds of witnesses who are prepared to testify that your guy is the guy that did it, including a co-conspirator. And there are a lot of other people in this mix that make this a very interesting story. But it looks pretty bad for your client, at least from the standpoint of what the evidence is that the state has. Before we get to the rest of that thought, let me tell you about a book. The book is called The Wolf Story, and you can hear it read to you here on YouTube. I'll drop the link in the description. But it's a great book because it's the story of Little Red Riding Hood as told from the wolf's perspective. And it's about how he used to help the grandmother, and he never really liked the kid because the kid brought toffee and it caused the grandmother's teeth to stick together. So it's a really well done tale that essentially tells the wolf's side of the story. And it's funny because we all know the story of Little Red Riding Hood, and we know that they named him the Big Bad Wolf for a reason. So for that reason, just the idea that you could create a story about how you could make the wolf look like not a bad guy, that sort of tells you a little bit about what it's like to be a defense attorney in a case like this. You have the Big Bad Wolf on trial, and you're trying to explain that Little Red Riding Hood was the problem, not the Big Bad Wolf. So that's where we are with Justin Johnson's case on day 2 of the murder trial in the Young Dolph case. Now, what's interesting about this is that so far we've heard a lot of different evidence, and much of the evidence comes in with witnesses only shot from basically chest level down, which makes it impossible to look at what's on their face or their facial expressions when they're offering their testimony. They did this purportedly to protect some of these witnesses, although I don't know how much protection they're actually offering them by not showing their faces. I think it's more a matter of preference for these witnesses. And to be honest, I don't think that's appropriate. I think the judge made a bad call in granting that motion, but that's the judge's prerogative, and she probably knows better than I do whether that's a good idea or not. But in this first video, we're going to watch the defense attorney raise some reasonable doubt. Many of you who are somewhere close to my age may have heard the aphorism that, about how you eat an elephant. How do you eat an elephant? It's a huge thing. It would take weeks for one person to eat that. How do you eat the elephant? Well, you do it one bite at a time. And that is precisely what the defense attorney is showing us here.
And you also received back into evidence from the medical examiner several bullets and bullet fragments. Is that correct?
That's correct.
And to your knowledge, at any point in time, did anyone try to test those, not just put them to a firearm because you didn't have the particular firearm, but to determine what caliber of bullets were recovered from Mr. Thornton?
Should possibly, yes. The crime scene or whoever took custody of those bullets.
Okay. You're saying it's possible, but are you aware of any testing? Okay.
So he asked all of these questions about the bullets that were recovered and whether anybody ever linked them to particular calibers, because one particular caliber was used by the co-conspirator who testified that he participated in the unaliving of Adolph Thornton. The other caliber was apparently from a different firearm, and the fact is they don't have it tied to this particular individual, Justin Johnson. And of course, the state says that's because Justin and Cornelius, the two people who are alleged to have actually pulled the triggers, threw them away, basically disposed of them in a way that they could not be found. And that's probably true. But you don't know whether it was Cornelius or somebody else who may have actually done the killing because of the way the defense has set this up. So he asks about this, and he finds out that the police didn't get that information. And one would think that would be a fairly important thing to nail down. But there are sometimes facts that you don't gather because you just don't want to know. And that also is an important factor. Now, in this next segment, we're going to be looking at the questions he asks about video, because the state has relied very, very heavily on video, but there are gaps in the video. And one of the things that the defense is going to point out here is there was video available if the cops had actually seized it, and apparently they did not, because they considered the person who had that video to be a suspect in this matter. As a result, they didn't get the video. But again, the purpose of this is to raise reasonable doubt. And next, the defense attorney is going to challenge some assumptions about video that was recorded. Now, it's fairly clear that somebody gets out of the car at the point in time where the unaliving is done. But later on, someone gets out of the car that they are essentially saying was used to transport the people who did the evil deed, and the detectives made certain assumptions about the people who supposedly got out of that car. But as he's going to point out, those assumptions may not be reasonable.
And you would agree with me that during those periods of time where the white Mercedes, it shows the white Mercedes in the video come in, you can't see the driver, you can't see the person in the gray sweatpants and the black hoodie, what they get in and out of. You can't say that that person was ever in that white Mercedes, correct?
No, you can't. It's just the area that the Mercedes parked at is the same area where that person came from.
Well, but can you even see in the video that was shown where the Mercedes parks?
No, just the general area.
Which is the parking garage, which is around hundreds and potentially more other vehicles, correct?
Correct.
Okay.
It's fairly clear that the lawyer here, the defense lawyer, is not going to win a lot of points with the professional witness on the stand, the detective. The next witness on the stand, however, is a member of the peer group of the gentleman who did the evil deeds, allegedly. And his response in some of this is pretty interesting. This is a cross-examination where he is going to give some answers that are simply not believable. And it's interesting the way that the defense attorney points that out. Again, this is just him going after the witness and essentially taking one bite at a time out of that very big elephant that the state calls its case in chief.
So, how many times have you been interviewed by law enforcement before today?
Too many times.
2 minutes. In relation to this investigation, if that narrows it down any for you, is it still too many times? Or are you just saying one time's too many?
One time, too many.
Sure. Fair enough. So, you've at least been interviewed twice, right?
Yes, sir.
And then you even got spoken to right before you came on the stand by the state, correct? And the first time you talked to law enforcement was on November 23rd, 2021 about this. Do you remember that?
Yes, sir.
And you told this jury today you had no idea that Mercedes-Benz was stolen.
No, sir.
Now that just isn't true. And you know it's not true, right?
I wouldn't been in if it was stolen.
Okay. What's Trayon do for a living?
I can't tell you.
I mean, Did he have a job that you knew of where he could afford a Benz?
Yes, sir.
He did. What'd he do?
Work at a garbage truck place.
Okay. What? I mean, you weren't with Trayon when he carjacked it a couple of weeks before. I mean, you and him were tight, right?
Yes, sir. If I would have been there, I would have said, no, I wasn't.
You weren't there?
No, sir.
And you just, I mean, how long you known Trayon?
My whole life.
You've known him your whole life.
Yes, sir.
He works at a garbage company,
Yes, sir.
right? He's driving a Benz. How long had he had the Benz?
I can't tell you.
I mean, you hung out with him almost every day, didn't you?
No, sir. You only kind of pick me up when I need a ride.
Did you need a ride the night you say you went over and traded the Benz?
Yes, sir.
Where were you going?
Off Redwood in the mile.
And Trayon was just taking you.
Yes, sir.
Well, what did you think when he was going to trade his nice bought and paid for Mercedes-Benz for an Infiniti Q40?
This is business. That's what I thought.
Let me ask you this, Piston. For Trayon and you riding around in this Benz that you thought he bought and paid for, didn't carjack to get it, what did you think when he was riding around with 2 pistols and a Draco in the back?
Text is meant.
Because that's what he had, right? A Draco style assault rifle.
I can't tell. I just know he had some type of weapon.
Well, you called it a Draco when you interviewed with law enforcement.
Yeah, it should be.
Right? So that's what it was. And some pistols, right?
It was a lot more than that. It was plenty guns in the car.
And that's what you and Trayon were riding around with.
Yes, sir.
So one of the things that I asked you to notice in the first part of this was how calmly the detective sat there and answered questions that were put to him. But what do we see when Kirsten Walker here is giving his testimony? Well, we can't see his face, so we can't see the worry or the look or anything like that in his eyes, and he's probably looking down anyway. But what we can see is him swinging back and forth in his chair. That's what most body language experts would call a self-soothing behavior. In other words, it's designed to help him mitigate the stress of testifying at trial. And he's already testified on direct, and now he's being cross-examined, and the stress is greater, and he's weaving back and forth because he's stressed. So the attorney here, Luke Evans, who is representing Justin Johnson, is putting on a bit of a masterclass in how you take apart a state's case one piece of evidence at a time. That's because the state has the burden of proving everything beyond a reasonable doubt. And that's a pretty high standard. And all he has to do is get one juror to essentially deadlock the jury and maybe not get an acquittal, but he would at the very least get a mistrial. And there's only so many times that the state is going to retry a defendant. But more importantly, once you get one mistrial, it's usually much easier to get an acquittal because subsequent jurors are going to think, well, if they presented this case before to the other panel and they didn't find him guilty, well, then surely, there's something here that we're missing. So that creates a bit of a higher degree of stress on the state the next time they go at it. But here, all he has to do is get one juror, and he knows that. And so what he's doing is he's raising doubt incrementally as he goes along in all of these people's testimony. And from what I've seen, he's done a very good job of that. In other words, he is about halfway through writing the wolf story here. He has a narrative that they set this kid up, and he's getting that in through many of these witnesses. And keep in mind, I'm sure he has witnesses to call who are going to help him with his side of the story as well. So that's what I have for you today. Thank you so much for watching. If you have the opportunity today, go out of your way, do something nice for somebody, and call that a good day. Oh, and I asked you before, tell me what you think about how effective the defense counsel is in this case. I think he's doing a pretty good job, but I'd love to hear your opinion. Drop them in the comments down below or send me an email at the address above. And thanks again for watching. Come back tomorrow, catch me down here at the beach, and we'll talk about something else. Hey, as I said at the beginning, none of what I said is legal advice, but let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.